Hi, I'm Burt True with True & Associates, and today we're going to talk about health insurance plan reimbursement from your auto wreck settlement. When you signed up for health insurance at work, they probably didn't tell you that if you get in a car wreck, they're not going to pay. Or at least, if they do pay, they're going to require you to pay them back. This is a concept called subrogation, when one insurance company tries to recoup expenses for a claimant paid from another insurance company that is responsible for paying a portion of the claim. Your health insurance is claiming that they get paid back from the auto insurance that covers your wreck. Well, the good news is, a long time ago, the state legislature came to your protection, came to your rescue here. In Missouri, public policy prohibits the transfer of personal injury claims, in whole or in part. This prohibition actually dates back to English common law in the Middle Ages. But there's a recent Missouri court case, came down August 6, 2010, called Scroggins versus Red Lobster. In this opinion, the court held that the person the health insurance company was trying to get paid back from had paid for her health care coverage, and that the insurer is obligated to cover the expenses. And this is a quote from the court: "Missouri courts have never allowed a provider to be reimbursed for medical expenses that the insured recovers in a settlement from a liable third party under a lien theory, and we decline to do so now." So what that means is your health insurance can't get in front of you when it comes to getting paid for your auto wreck on your settlement. But your health insurance plan isn't done yet. These people have a lot of connections and a lot of pulls. So what they do is they go to the federal government. And there's a law enacted by the federal government called ERISA. It stands for Employee Retirement Income Security Act. And as we all learned in wherever they might have taught it, the Constitution says that federal law trumps state law. It's called the Supremacy Clause of the Constitution. So always remember that federal law trumps state law. So the health insurance plan claims to be governed by this federal law called ERISA. And this is where the analysis really gets complicated. Because ERISA does preempt state law, but there are exceptions. State laws that are not preempted by ERISA, and those exceptions are listed right there in ERISA. One of them is state insurance law. That's one exception. But then there's an exception to the exception. It's called the Deemer Clause. And that exception to the exception says that if the health insurance plan is self-funded, then state law is preempted. So your health insurance plan claims, of course, that it's self-funded. What does that mean? If the employer provides health insurance to its employees with its own funds, that's self-funded. There can't be any insurance component to the health insurance plan. But see, a lot of these plans, your employer doesn't want to take the risk that an employee might get cancer or have some very bad situation, severe injury or disease, where the expenses are quite high and could theoretically even bankrupt the company. So they'll purchase what's called stop-loss insurance. And it's an insurance policy that kicks in when the medical bills get to a certain amount. Okay? Is that plan self-funded? There's a difference of opinion here. I, of course, would argue no, because I represent the little guy. And your health insurance plan debt collector will argue that, yes, the plan is self-funded. Now, courts have gone both ways on this issue, and here's where a good lawyer can add value. Rather than risk a bad precedent, your health insurance plan would prefer to just go ahead and settle with those people who have good lawyers who know the law, so that they don't get a court case on the books that says they can't collect at all, which would prevent them from collecting from anyone, even those who don't hire a lawyer or those who have a lawyer who doesn't understand ERISA subrogation law. So what they'll do is they'll settle with these few clients and continue to keep collecting the free money from those that don't hire a lawyer. So in some cases, I have reduced the amount that has to be paid back to the health insurance plan to 10% of the medical bills that were paid. And that's just because I'm able to negotiate those settlements because the health insurance plan does not want to have a court case come down and be put on the books that says you can't collect it all. Now, there's one more thing to always remember. Wrongful death claims are not subject to health insurance plan liens for medical expenses. So don't let somebody claim that they get repaid out of a wrongful death claim if you have a family member killed in a car wreck. Next week, we're going to discuss the question, can I recover from my own auto insurance? I'm Burt True with True & Associates. If you have a suggestion for a topic, please post it in the comments below. And you can subscribe to my blog by email. Just click the link below that says subscribe by email. You can also follow this blog using Google Friend Connect. This will keep you updated with new posts to the blog. If you're watching on YouTube, you can subscribe to my YouTube channel to get notification of new videos. And you can click the links to this video, on this video, to view my law firm's television commercial or other interesting videos on personal injury and wrongful death topics. If you'd like to discuss something in private, click the Google Voice gadget below on the blog and you can enter your telephone number and Google Voice will connect us. Thanks.